Okay, so I think everyone is here already. So we will start the first session of the seminar. For the first and second sessions, we will have the lecture titled International Litigation by Mr. Paul REICHLER. Mr. REICHLER is associate member at 11 King's Bench Work Chambers, London. He has been a practitioner of public international law for more than 40 years and has represented states in disputes in a variety of cases at the ICJ, ITLOS, and international arbitral tribunals. We are very privileged to host him as the first lecturer of the seminar. Before starting the session, let me make an announcement on the publicity. Throughout the program, the lectures will be recorded for the record within the Ministry of Foreign Affairs. For publicity purposes, selected lectures will be posted on the Ministry of Foreign Affairs website afterwards. Please note that the participants will not be filmed, but audio will be recorded. We start, Mr. REICHLER, the floor is yours.
Good morning, everyone. Director General Kanai, distinguished friends from the Ministry of Foreign Affairs, and distinguished attendees from great states in Africa and Asia. It's a true privilege for me to be here among you, and especially to be among you here in Tokyo. In my opinion, there is no better place in the world for us to congregate to discuss the rule of law. I know of no state that has demonstrated a greater, more sincere, or more profound commitment to the rule of law in international relations than Japan. And so to be invited by the Japanese government to be here and to speak before you today is a distinct honor for me as a lifelong devotee to the practice of international law with the vocation of doing what I can in my own limited way to contribute to reinforcing, to strengthening the structure of international law that guides us and that strengthens and enforces the commitments of all states to respect the rule of law, which is the key to peace and security for all of us. One has to be humble, necessarily, in pursuing this vocation, because there are limits on what any of us as individuals can do, and we need to be aware of it. But it is by all of us, whether we're judges, professors, lawyers, counsel, state officials, all of us, the many thousands of us, the many tens of thousands of us around the world, who share this commitment to peace through the rule of law, that progress can be made. And I'm happy to be part of the same struggle, the same effort as all of you here. As Ono-san kindly said, kindly told you, I have been a practitioner of public international law for the last 40 or so years. And what I have done during this period is represent sovereign states in their disputes with other states before international courts and tribunals. This includes litigation before the International Court of Justice and the International Tribunal for the Law of the Sea, and also arbitration before the various international arbitral bodies, the Permanent Court of Arbitration, ICSID, the International Chamber of Commerce. And my practice has also included advising states in a pre-litigation or pre-dispute context, often on whether and how they can initiate and pursue dispute resolution proceedings before international courts or arbitral tribunals, and just as often on how they can avoid being hauled into an international court or tribunal to defend themselves, but to find other ways, apart from litigation, to resolve their disputes with other states. My CV, which has been distributed, identifies some of the cases in which I have had the privilege of serving as counsel during my career. I've been very, very fortunate to have had the opportunity to represent outstanding clients, wonderful states, including Japan, and to serve as their counsel in these proceedings. And some of them have been very interesting cases that have received a lot of attention. So in the course of these next few hours, which I will spend among you, if there are any questions that any of you might have about any of these cases, I'd be happy to answer them, either during the session or during the breaks. Now, in these two sessions, which surround the lunch break, I will discuss with you from the standpoint of a practitioner how international cases are actually litigated. By the way, can everybody hear me? Do I need to speak louder, or are you, you're all able to hear? Very good. Now, when I say that I'm going to discuss litigation practice with you, I actually hope that that will be the case. I hope I'm not the only one speaking during these several hours. The best professors, the best teachers will tell you that participants or students in a class or a conference, or really any group of people, learn less when they are only lectured to and spend the entire time listening, even when the speaker is far more gifted than someone like myself. As compared to how much they learn or retain when they engage with the speaker by asking questions, expressing their own views, even if, or especially if their views differ from those of the speaker, and by sharing their own experiences. And I hope you'll do that, because participation is a much better way of learning than passive listening. And it helps me learn from you if I hear from you, and it helps everyone here if we view this as an opportunity to learn from each other. Now, I have reviewed the list of attendees, and I know that quite a number of you are from states or international organizations that have had cases in the ICJ or in ITLOS, like Botswana, Cambodia, Djibouti, Ghana, South Africa, Thailand, Timor-Leste, and the African Union. I don't want to put any pressure on you by singling you out. I haven't mentioned your specific names, but I'm sure there are important contributions that all of you and everyone else here can make to our discussion, even if you yourself did not directly participate in the proceedings in which your state was a party. Please don't feel like you have to wait until the end to speak out or to ask questions. Your comments, questions, ideas, and experiences are welcome at any time, and I may pause from time to time to ask you for them. If you feel the urge at any time to make a comment or ask a question, I'd be very happy to call upon you. Just raise your hand and I'll call upon you at the first opportunity. One thing about being a litigator, which is what I call myself, is that we don't mind being interrupted. In fact, we welcome it. When a judge or arbitrator stops me in the middle of an oral pleading to ask me a question or to invite me to address a particular subject, that's a good thing, because it allows me to know what the judge or arbitrator is thinking, is concerned about, or what area of the case may be of interest to him or her. And it gives me an opportunity to meet that judge or arbitrator on his or her own terms, on his or her own turf, and address the concerns of that person who's going to be deciding my case. So I would say that the same is true here. If my mission here is to help you understand better how international litigation is practiced, I think we'll all be better off if you let me know from time to time what questions you have, what concerns you have, so that I can more directly address them. Now, my last introductory comment before I start speaking about international litigation is to say that it would take at least a full semester, if not an entire academic year, to teach a complete course on all aspects of international litigation practice. And we obviously can't attempt to do that here. But I think we can cover a lot of interesting ground today and impart some information and ideas to you, which I hope you'll consider valuable, by emphasizing the major practical aspects of litigating an international dispute. To that end, I plan to discuss the following topics with you. First, the decision to sue. What are the circumstances that drive states to sue one another or to decide not to sue? Second, the composition of the legal team. How is this done? What are the national components? What are the international components? And how are decisions on the selection of counsel made? Third, putting the case together, including the legal and factual elements, and how to structure the case that your state is planning to present. 4 is the commencement of the proceedings. How do we get started? What decisions do we have to make in determining how to get started? 5th is the preparation of the written pleadings. As you know, there are generally 2 phases, 2 principal phases in international litigation or arbitration, the written phase and the oral phase. There may be ancillary phases too, such as phase on provisional measures at the beginning, or there may be a separate phase at the end on compensation. But all of these phases involve both written and oral pleadings. So I will spend a considerable amount of time on the written pleadings because they're so important. And I will also spend an equally considerable amount of time on the oral pleadings because they too are extremely important. And sometimes their importance is not fully appreciated in comparison with the importance of the written pleadings. Besides, it's more fun to talk about oral pleadings. On the last subject, the oral pleadings, with which I will conclude before making some concluding remarks, I've arranged, thanks to our friends at the Ministry of Foreign Affairs, for each of you to receive a copy of an oral pleading made by Professor Dapo Akande of Oxford University before the International Court of Justice in February on behalf of the government of Japan in the advisory proceedings on the legality of the prolonged occupation, settlement, and annexation of the Palestinian territories by Israel. Professor Akande is a good friend and colleague, as well as a fellow lecturer at this seminar, and you will have the privilege and pleasure of hearing from him later this week. I'm requesting that you spend a few minutes of the lunch break reading this 9-page presentation that Professor Akande made on behalf of Japan to the ICJ. You don't need to read it now, but I think it is available in the back of the room. Maybe some of you have picked it up, but you'll have plenty of time during the breaks to go through it. When we resume after the lunch break, I'm going to ask you, any of you who wish to participate, and hopefully there will be several of you, to tell me why you think I asked you to read it. What is it about this oral? Of course, you will be reading it, you won't be listening to it, but it was his oral presentation. What is it about this presentation that strikes you, that that impresses you either way, as effective or not very effective? We can spend some time discussing it to illustrate some of the points that I will be making in the after lunch session on what makes an effective oral pleading before an international court or tribunal. Now, it should be apparent to you now that this is going to be a rather technical set of sessions. We're going to take together a deep dive into litigation tactics and strategies. I'm not going to lecture you about the law. Others will do that, and they will do a better job than I could. I'm not saying I don't know anything about the law. Obviously, I've learned a few things in the past 40 or so years. But my focus is on the practice of international litigation. Of course, we use the law. The law sets the boundaries within which we develop and present our cases. And my role in this seminar is to focus on that, on the practice of international litigation. So we're going to be talking about the nuts and bolts of the practice of international law. Now, I recognize that litigation, the adversary process is not everyone's cup of tea. And for some of you, it might not be something that you ever aspire to actually do yourself. So I will try to make this presentation useful to all of you, even those of you who don't envision yourself standing up in court someday, because it won't be a bad thing for you to come to understand better how litigation is practiced and how the litigators who your state retains to defend it think and act. So with that, that concludes the introductory part of my remarks. Are there any questions or comments before I start the deep dive? I'm going to give you a free pass this time. You don't have to raise your hand or ask any questions, but I'm going to be a little bit more aggressive in provoking comments or questions as we proceed this morning. All right. So the first of these topics that I've outlined for you is the decision to sue. And how is this made? Or how is the decision made conversely to avoid litigation or not to sue? So we start with the question of with whom, with what other state do we have a dispute, and what is the dispute about? And we ask first, at least we as litigators, when we're invited to consult with the state on this decision, we ask, what is the claim? What is the potential claim? The state might not have fully appreciated what claims are available, and so we are consulted as legal experts on the potential claims once we understand the nature of the dispute. Has the other state violated its legal obligations to you in ways that can be recognized by an international court or arbitral tribunal? What is the injury suffered as a result of this or these violations? And is it possible to obtain relief, whether it's compensation or cessation of the offensive practice from a court or arbitral tribunal? Now, once we have identified the dispute, the nature of the claims, and the reachable objectives, that is, what it is realistic to expect from a court or arbitral tribunal if we succeed in proving our claims, we have to ask, is there a better way to resolve the dispute than by suing the other state? For example, have we attempted negotiation? Is it possible to reach a satisfactory solution by agreement, by diplomacy? If that has been attempted and we conclude that no further efforts would be worthwhile because they are unlikely to succeed given our experience with the other state, what else is available to us? Is there a possibility of conciliation or mediation? Is there a possibility of good offices by a third state or by the Secretary General of the United Nations? Article 33 of the United Nations Charter gives a list of peaceful dispute mechanisms: conciliation, mediation, arbitration, of course, litigation, good offices by a third party who is respected by both states, and who is disinterested and experienced in promoting dispute resolution. Litigation should not ever be the first choice because of the costs and risks involved. But it is often in the end, or at least sometimes in the end, the only choice. And the reason that it needs to be the last resort is because of costs and risks. And these costs and risks are of different kinds: political, administrative, commercial, economic. What will be the effect on the bilateral relationship if your state sues its neighbor? Of course, the effects will differ depending upon which state you are planning to sue, how powerful it is relative to your state, and from what you know of it, how is it likely to respond? And is it likely to respond in a way that will make you regret having brought them to court? I'll give you some examples of cases in which I have been involved that raise these questions and relate to you how, in the cases in which I've been involved, the states weighed and balanced these risks and costs before coming out with a decision to go to court. And after I do that, I'm going to, I'll give you a heads up here, I'm going to ask some of you whose states have been to the ICJ or ITLUS what process your state went through before it decided to resort to litigation to resolve its dispute. So some of you might want to be thinking about how you would respond when I ask for that. But the costs depend in part on how you evaluate the potential reaction of the other state. And the risks are, will it respond militarily? Is this a dispute over territory? And by suing, will your lawsuit result in more aggressive action by the other state, including to seize the disputed territory, and thus be counterproductive to your efforts to resolve the dispute according to law? The other state might resort to commercial measures. You might find yourself subject to a trade boycott or to restrictions on your exports to that state. Even apart from how the other state might respond to your lawsuit, there are inevitable costs. There are financial costs, hiring counsel, even the costs that you incur with your internal team, the national element of the litigation team, which I'll come to that a little bit later. But there are costs in terms of their time. And instead of performing their usual functions, they're going to devote a huge amount of time to the litigation. And there are out-of-pocket costs because there are travel expenses to meetings of the legal team and travel expenses to The Hague or Hamburg or wherever the arbitration might be held. So all of these costs and risks must be taken into account, and you must come to the decision that because of what is at stake, and because you can't accept the status quo that's been imposed upon you by your neighbor, that litigation is worth enduring these costs and risks. Now, before I get to how, in my experience, certain states have resolved these questions, let me address, or at least identify, some of the other issues that must be taken into account when deciding to sue. And one very, very critical judgment that has to be reached is there jurisdiction? We might have a great case, and we might decide that it's worthwhile, despite the costs and risks, to bring the case. But is there a court or arbitral tribunal that will hear us? Is there jurisdiction in the ICJ? Director General Kanai indicated that Japan, I will add to its great credit, accepts the compulsory jurisdiction of the ICJ under Article 36(2). I think there are about between 60 and 75 states that do. That is unfortunately a minority, but it's a significant number. ICJ jurisdiction is also possible under treaties, under bilateral treaties, some of which provide for dispute resolution in the ICJ, and under many multilateral treaties, which provide for ICJ jurisdiction of disputes that arise under those treaties. Sometimes you have to be inventive in thinking about what treaty might exist that would give rise to ICJ jurisdiction. And sometimes, because the treaty only allows you to get to court over matters covered by the treaty, you have to consider whether you might want to reframe the dispute so that it meets the jurisdictional requirements. I'll give you a concrete example of that. In 2008, Russia invaded Georgia. It crossed the border into two Georgian regions. One was South Ossetia, another was Abkhazia. When Russia invaded, its purpose was to take these regions of Georgia from Georgia and set up independent states that would be loyal to Russia. I'm not talking about Ukraine here. This was the prototype that Russia introduced in 2008 against Georgia. Now, Georgia was under tremendous pressure. In fact, the Russian military forces had descended south beyond the limits of South Ossetia into Georgia proper. And the Russian tanks were 40 kilometers from Tbilisi, the Georgian capital, and moving in that direction. And Georgia obviously was active diplomatically in the United Nations and other fora, and had attempted to negotiate with Russia, but there was no response. And so Georgia decided to go to the International Court of Justice and to seek provisional measures to try to get the court to order a halt to Russia's aggressive activities. Now, this was a case of aggression, of cross-border use of force by one state against a sovereign state that was an obvious violation of Article 2.4 of the UN Charter and general international law prohibiting the use of force by one state against the sovereign territory of another. But there was no jurisdictional basis for Georgia to sue Russia for aggression or for specifically unlawful use of force. So Georgia looked at the various treaties that Russia or its predecessor, the Soviet Union, had signed, which gave jurisdiction to the ICJ, and it discovered the Third Convention, the Convention on the Elimination of All Forms of Racial Discrimination from 1965, the Soviet Union was a party, and Russia, upon its emergence as the successor to the Soviet Union, acceded to it. And so Georgia framed its case against Russia as one of ethnic cleansing, ethnic discrimination, and thus invoked the court's jurisdiction and succeeded in obtaining provisional measures. At that stage, the standard is prima facie jurisdiction. The case didn't end so happily for Georgia, but I'll come to that under another topic. But this is what I mean when I say sometimes it's necessary to be creative in finding a jurisdictional basis for your case. And of course, another jurisdictional basis is the compromis, or agreement. Two states that are desirous of resolving a dispute can agree together to submit the dispute to the ICJ for resolution. I'm involved in one of those cases now, which is going to be heard by the court the first week in October. Equatorial Guinea and Gabon have a long-standing dispute over their land boundaries, their maritime boundaries, and especially over sovereignty of certain offshore islands. And the two states, after years and years of unsuccessful negotiation, finally agreed to submit the dispute, or at least part of it, to the ICJ. And after 2 rounds of written pleadings, the case will proceed to oral hearings before the court, as I said, the first week in October. Another issue that arises again in the decision to sue is, what if jurisdiction is available in more than one place, ICJ or ITLOS or international arbitration? There may be some of you whose states have faced this question, and you have to evaluate the prospects for your state. What are the benefits? What are the risks of going to one form rather than another? Generally speaking, the advantages of going to the ICJ are, it is the ICJ. It is the International Court of Justice. It is the supreme judicial authority of the United Nations. It is the highest international court in the world. And its decisions and judgments, therefore, carry more weight. And although the court has no army to enforce its judgments, there is a great deal of pressure to comply, because states do not like to be considered international outlaws, although some do, and some have successfully defied the judgments of the court. They're actually very few in number. The vast majority of states, in the vast majority of cases, comply with the judgments of the court, even if they're unhappy with them. There may be an advantage to going to ITLOS, where if the issue concerns law of the sea and you have the experts on the UNCLOS, on the Law of the Sea Convention, you may decide, when you look at the composition of the two courts, although judges almost always decide cases based on the facts or law, there is, at least when council or states decide which court to go to, they do take the composition of the court and the states that the judges come from into account. And you may find yourself more comfortable in the ICJ or ITLOS, depending upon the composition. And in terms of arbitration, the advantages of arbitration are that you get to select the arbitrators, or at least some of them, and you get to agree on who is the chair or president of the tribunal. Arbitration also is much faster, much more efficient, and that can be an advantage in getting the dispute resolved earlier. It's also more expensive because the parties have to pay the fees of the arbitrators and the administrative fees of the of the arbitral body, whereas the parties don't pay administrative costs or the salaries of the judges if they go to the ICJ or ITLOS. So these are all key factors. Maybe I can encourage some of you to speak about the cases in which your states were involved by giving you some examples of cases in which I participated in how and why the states concerned decided to sue and how they compared the need or the benefits of going to court against the risks. So I'll start with the first international case that I did, which started exactly 40 years ago, was Nicaragua versus the United States. There were times when I included this case in lectures that I gave when everybody was familiar with the facts because it was a notorious situation in the 1980s, but now 40 years later I have to assume that people are not as familiar with the circumstances as they were a couple of decades ago. But at the time, the United States was attempting to overthrow the government of Nicaragua, which was the product of a revolution that overthrew a military dictator and a military dictatorship that had lasted for 45 years with, unfortunately, the support of the United States. And the United States, this was, of course, at one of the high points in the Cold War, and the United States considered the Sandinista regime in Nicaragua to be communist and hostile to American interests. Of course, international law that's not a justification under international law, even if it were true, which it wasn't, for invading a country, either directly or indirectly, and overthrowing its government. Nicaragua had tried for years to engage the United States in diplomatic talks and reach a settlement. Negotiations failed. It was the explicit policy of the American government at the time to overthrow this government. And what they did was they organized a group of a military force from the forces of the former dictatorship. They organized them, they armed them, they trained them, and they directed them from bases in Honduras and Costa Rica, the two neighboring countries, to attack Nicaragua. So faced with a threat to its very survival and with no diplomatic solution, Nicaragua decided to sue the United States in the International Court of Justice. At the time, it was considered a bold move because historically the court had been seen as largely a Western institution that had been dominated by the Western powers, European and North American powers, and reflected their influence. But this offered the court an opportunity to show that any state, any small state, any state from the global south, or what we used to call the third world, could take on the world's greatest superpower at the time on an equal footing and receive justice. And that is what ultimately happened. Those of you who are familiar with the case know that it turned into a historic victory for Nicaragua. And apart from that, what many judges and former judges and registrars of the court had told me is it had a tremendous effect worldwide on the credibility of the court. And you can see, starting from that judgment in 1986, much greater resort to the court, particularly by states outside of Western Europe or North America. And the court has become busier and busier. And for those of us who, like all of you, who are committed to the rule of law, increased resort to the court, increased resort to judicial means to resolve disputes according to the rule of law is a great thing. And the court, I'm very proud of the way the court has conducted itself, particularly over the last 40 years that I have been familiar with it. And I think the court does its job. And it is one of our great hopes, great opportunities to promote the rule of law. And it deserves our support. I hope more states will follow Japan's lead and accept its compulsory jurisdiction, or at least find ways to join treaties where dispute resolution by the court is one of the provisions. There was a complicated situation affecting Bangladesh, surrounded by, in terms of its access to its maritime entitlements in the Bay of Bengal. Bangladesh's coast and the northern part of the Bay of Bengal is concave, and it sits between Myanmar on one side and India on the other. And for those of you, I won't get too much into the technical aspects of maritime delimitation, that's beyond the scope here, but just to present the situation, equidistance lines from both coastal termini, because of the concave nature of the coast, intersected a very short distance off of Bangladesh's coast. And both Myanmar and India were claiming as the maritime boundary an equidistance line, and that completely cut off Bangladesh from its maritime entitlements out to 200 miles and beyond. So Bangladesh was faced in a situation where it would do limited good to take a dispute against India unless it also initiated one against Myanmar. And so it commenced two arbitrations, one against India, one against Myanmar, to delimit their respective maritime boundaries. One of those cases ended up in ITLUS by mutual agreement, the case against Myanmar, and the case against India proceeded to arbitration. And as a result of those two arbitrations, new and more equitable boundaries were created between Bangladesh and its neighbors on both sides. I don't want to spend all of our time talking about how these cases came about, but there are one or two more that I think you'll find very interesting. Am I right that you're interested in this subject? Can I? One that you might find particularly interesting, particularly those of you from Asian states, is the South China Sea arbitration between the Philippines and China. Starting in about after 2009, China began to assert a claim to sovereignty over almost the entirety of the South China Sea, based on what it called, you may know the terminology, the so-called 9-dash line. The dashes appeared on old Chinese maps. created kind of a semicircle extending across the South China Sea, almost to the coasts of Malaysia, Indonesia, Philippines, Vietnam, etc. Within this area, China began to claim the exclusive right to all the resources, and even to control freedom of navigation. In respect of the Philippines, the so-called 9-dash line extended. It was within 50 miles of the Philippines coast, and at those points it was more than 600 miles from the Chinese coast. The Philippines attempted negotiation with China over many years because under the law of the sea, it had entitlement to an exclusive economic zone and a continental shelf up to 200 miles from its coast. And there was no overlapping 200-mile jurisdiction from the Chinese coast because it was 600 miles from the Chinese coast. The other states with coasts along the South China Sea were fully supportive of the Philippines, Vietnam, Indonesia, Malaysia, but were more reluctant to engage in a confrontation with China over it. And ultimately, the Philippines, under the guidance of not only a brilliant, but I would say a heroic foreign minister who has since deceased, Albert del Rosario, and President Aquino, decided to explore litigation or arbitration. And I was honored by being the lead counsel in that case. Of course, we had a team, but the challenge was to develop a theory that would survive a jurisdictional challenge, because China, like a number of states, including Japan and South Korea, have submitted declarations under Article 298 of the UNCLOS Convention, excluding themselves from arbitration of maritime delimitation. Not other aspects of the Law of the Sea Convention, but delimitation of boundaries. So we developed a theory that our case was not about delimitation, because delimitation occurs when there are overlapping claims. That is, if two states are less than 400 miles from each other and their 200-mile projections necessarily overlap. Here, because the area in question was more than 200 miles from China and within 200 miles from the Philippines, our case was to ask the arbitral tribunal to determine entitlements. Who had entitlements, legal entitlements, to this area within 200 miles of the Philippines. And ultimately, the court accepted that it had jurisdiction to make that determination, and ultimately ruled that only the Philippines had entitlements out to 200 miles from its coast, because China's 200-mile entitlements, which it had under the Law of the Sea Convention, did not extend that far and did not overlap. The arbitral tribunal, there were other issues in the case. It ruled unanimously. It was a very strong ruling in the Philippines' favor. Unfortunately, as you all know, China rejected the award. And although in some ways it has de facto, or for a period of time, it has de facto complied with it, more recently, as we see from news reports, China has been more aggressive in restricting the exercise of rights by the Philippines within that 200-mile area. So the dispute has reemerged. And this is one case where a resort to arbitration, resort to the rule of law, has been frustrated. Maybe there's hope for engaging China in some other way, but this has become a problem again. There are other cases that, one other one I think, if you don't mind, I'd like to talk about because I think it'll be very interesting to you, where a state decided to sue where its own interests were not directly affected. And this is the case of Gambia against Myanmar. Following the mass slaughter of the Rohingya Muslim population by the Myanmar government in 2017 and 2018, which led to the exodus of almost 1 million Rohingya across the border into Bangladesh, which now constitutes the largest refugee camp in the world. Following that, the United Nations created an independent fact-finding mission to determine whether the slaughter of the Rohingyas amounted to genocide. In parallel with those United Nations investigations, the OIC, the Organization for Islamic Cooperation, created a committee within the OIC to make its own investigation. And one of the members of that commission was the Gambia, represented by its then Attorney General, who had previously served as a prosecutor in the War Crimes Tribunal for Rwanda, and the UN Special Tribunal that had been created, and had prosecuted genocide cases against those who had carried out genocide against the Tutsi population in 1994. He was very sensitive to the issue. And when they went to investigate, to collect testimonies from the refugees who had been witnesses, he became, how can I say, distraught, but also energized. And he told his colleagues from the other OIC states, I know genocide, I've seen it, and this is it. And so the Gambia became the leader in the OIC to call the world's attention to this genocide. And when the UN Fact-Finding Commission issued its report, there were 2 voluminous reports in which they concluded that there was genocide. The OIC met and they selected the Gambia, which willingly accepted, to bring the case in the ICJ against Myanmar. So we did that in 2019, and we succeeded in obtaining very strong provisional measures issued unanimously by the court, and that case is still pending. We're in the merits phase, awaiting the final rejoinder, the final written submission on behalf of Myanmar, and we expect that there will be oral hearings in the case sometime next year. But here's an example of a case deciding to sue, not because its own interests were directly affected, but because of its interest in holding accountable the perpetrators of genocide. And that leads me to another case under the same convention. And I have not met the person who is here from South Africa, so I don't know in which direction to look. And I'm sorry if I'm bringing pressure on you, and please feel free to decline my request, but if you can discuss what I have been discussing, but in relation to your state's decision to sue Israel for what is alleged to be genocide in Gaza. I know I would be excited to hear what you have to say, and I imagine the rest of us would be interested. So I don't know, is there someone here from South Africa? I know you're on the list. There you are. I hope I'm not putting too much pressure on you, and I hope you don't mind talking to us about the case and how South Africa came to decide to bring it. We're going to get you a microphone. By the way, who are you, if you can identify yourself?
Yes, good morning, Professor. Good morning, everybody in the room. I'm Ms. Tarusha Naidu. I'm State Law Advisor at our Foreign Ministry in South Africa. I was not expecting questions this morning, but I will take the opportunity and seize this on behalf of my state. As you all know, that in South Africa we had the system of apartheid. That was a regime that lasted many decades. This case is still presently, of course, as you all know, pending before the ICJ, and there's many things that I'm not going to be able to say, and or allowed to, as you all know. With regard to the regime we had, this hits home for South Africa when it comes to apartheid and genocide and human rights. And this is something that also our former president, Nelson Mandela, was close to his heart when it came to the Palestinians and all that they were enduring. This was a decision that was not taken lightly, nor was it a decision that was taken very quickly. This was a process, this was a long coming, and there was many things that South Africa took into account politically and legally, and actually all the factors that was mentioned here today on costs and risks, these are actually all things that have been weighed, as I'm sure every state weighs these factors when taking any matter to the ICJ. On that basis, this is the reason why South Africa has acted. This hits home for us, and we are not a state that only acts on our behalf. As our Madiba always says, that we have to look to the light and we have to act on behalf of those who cannot act for themselves. And that is one of the bases in which our government today, on the foundation of what was built on what we call the father of our nation, Nelson Mandela, brought the case. And I hope that's sufficient enough. If there's any questions anybody would like to ask me, the break time, I'll be willing to speak to you.
Thank you very much. I really appreciate that. I think all of us do. With that, let me move to the next topic. And I can't help but saying this. I'm speaking on behalf of myself only, but I greatly applaud South Africa for taking on this mission of ending genocide and ending the killing of innocence, and taking it upon itself when it wasn't directly affected, although these issues are of great sensitivity to South Africa given its history. I think your government has performed a great service to the world, and certainly to the rule of law and to human rights. And so I'm tremendously impressed. Congratulations. The composition of the legal team, I'm going to go over this rather quickly so we can get to the more substantive parts of the practice. But there are two components to you've decided to sue now, and so you need to decide who the lawyers are. And there are two components. There's the national element, which is extremely important, which, first of all, which agencies of your government are going to be represented on the team. There may be more than one ministry that has a particular interest in the case. Often, in some cases, it's handled through the Attorney General or Minister of Justice or Solicitor General. In other states, it's handled principally by the Foreign Ministry. But often, there are other ministries that are stakeholders or see themselves as stakeholders, and you need to have buy-in from different parts of the government in order to have a coherent and consistent position throughout the case. But it needs to be clear who is in charge, which ministry is, and who in the ministry is actually leading the team and responsible for having the proper decisions made. This is also, the national team is also important because it's important to build expertise in public international law and international litigation within the country. Many countries do not have these skills or experiences in-house simply because they don't spend enough time in court. And so there's been no reason or opportunity for them to develop experienced public international lawyers in their own countries. And that's one of the reasons they look outside for experienced counsel. But it's important to seize every opportunity when you are in court to train your own people, to develop as much skill in-house, so to speak, as possible, not only to stand up and represent your state in court, but also to be able to better manage the international component of the team so that the state is always in control. Now, in the international component, and that's usually where I come in fact, it's always where I come in, there is a need for experienced counsel. There is a need for experienced lead counsel in the sense of being the leader of the international component. The state itself is always the lead on the team. And this is, I think, fairly obvious. You need somebody who has experience before the court, whether it's the ICJ, ITLOS, or an arbitral tribunal, or experience in the subject matter of the dispute, whether it's law of the sea, use of force, human rights issues, genocide, ethnic cleansing. And somebody, it also helps to have somebody who has been a successful leader of other teams. Partly because the success of the team and the success of the state depends in large part on the team functioning well, on there being what we call good chemistry. Everybody is cooperating and collaborating and working toward the same end, which is winning the case. Now, that's fairly obvious, but it's not always achieved. I've been around international lawyers for most of my life, and almost all of us, and I don't exclude myself, have big egos. And the question is whether you have team members who are capable of subordinating their ego needs in the interests of the client and the proper functioning of the team. Now, that's not always achieved. I've been on teams where there have been very prominent, well-regarded public international lawyers. Obviously, I'm not going to mention names here, but whose egos are so large that when a younger member of the team has a new idea or questions the idea presented by the high and mighty, reacts badly and silences the person or refuses to really consider a re-examination of his or her position, because the attitude is, look, I'm the expert here, and who are you to question me or challenge me or come up with an idea that I haven't thought of? If I haven't thought of it, obviously it's not very worthwhile. This happens from time to time, and what happens is people get demoralized, and younger people in particular stop talking. They stop giving ideas, and the team suffers as a result. A good leader, and this is true in many contexts. I'm familiar in the context of a legal team. A good leader tries to get the best out of everybody, encourages everybody to talk, everybody to raise questions, everybody to raise challenges. When we're sitting around the table making strategic decisions on what to argue and how to argue it, it is not important who has the best idea or whose idea it is, whether it's from the senior, most experienced member of the team or the most junior. What's important, and what has to be important to all of us on the team, is we get the best idea, wherever it comes from. And most good ideas are really an amalgam. They come from suggestions from various people who see things from various perspectives. So what is extremely important, and doesn't always happen, is when you choose people, especially from abroad, to be on your team, and especially to be the leader of the international component, you want to be sure that these are people who are open-minded, who, even whatever their experience level, whatever their so-called prestige, that they are humble enough and dedicated enough to encourage everyone on the team to speak, to give their ideas, to consider everyone's idea and every point of view. And it creates not only harmony on the team, it encourages everyone to participate and do their best, and it results in the best ideas and the best strategies. Now, having said that, I'll give you one example. I was a late addition to a team, and when I joined, because I knew the other members, two very senior members. One was British, one was French, and there was a dinner at the ambassador's house. The ambassador was the agent in The Hague, and so at one point the British lawyer came up to me and said, "Paul, I'm so glad you're on the team. You've been added because it's just impossible dealing with our French friend." And about 15 minutes later, at the same dinner, the French lawyer came up to me, and I won't imitate a French accent. I don't do a very good job of that, but maybe you can superimpose it. He said, "Paul, this professor is impossible. He's worse than ever. You can't talk to him, everything." So what we had really were two rivals on the team trying to recruit me to their side. And you realize that's a dysfunctional team because we could see it in the team meetings. Whatever one said, the other disagreed with. And this occasionally happens. You have to work to avoid this, and you have to do it by your careful selection of the counsel, and also the national component, usually led by the agent, has to make clear that that's not acceptable, that this is not a group of children playing in a kindergarten sandbox. This is for real. The most important interests of the state are at stake, and we expect everybody on the team to behave in that manner. So the client, even though you may have little experience in international litigation and you retain a team of lawyers who are at the top of the profession, the client must at all times maintain control and make the final decisions, obviously informed by advice from counsel. Once you've decided on the suit, where to go, you've assembled your team, before you actually start the proceedings, you have to put your case together. What is your case? You have to know what you're going to argue and what you're going to ask in the way of relief. What is your case? The case essentially has two components, the legal component and the factual component. Well, the legal component, you're going to, of course, have studied that yourself. you're going to obtain the advice from your experts on the subject nationally and internationally. The research is going to be done. The law is going to be analyzed, and the legal principles are going to be understood, and your argument on how the law should be applied to your case so that you prevail will be developed. What I want to, this is of course critically important, but what I want to focus on is the other component, is the factual component. Because this can be the more complicated and the one where perhaps the experiences that I've had can be most helpful to you, and so I'd like to share them with you. I think that most experienced international litigators will tell you that most cases are won or lost based on the facts. If the law is decidedly against you, most likely you will not bring the case in the first place. So you have decided that you have legal rights that have been violated, that your adversary has legal obligations that it has failed to fulfill. How do you prove that? How do you actually prove it? You prove it with the facts, with the evidence. So how do you start? How do you do this? And what I'm going to reveal to you are my own trade secrets here. Some of them may seem rather obvious, but I think they're still worth mentioning. And some of them probably will seem new and different to you. So how do I envision this? I'm now invited in. I've been retained. We're developing the facts, the evidence to support the client's legal claims. What is helpful to conceive is, what are you going to present? What are you going to present to the judges or the arbitrators? You're going to tell them a story. You're going to present a narrative, but it is a story that has a beginning, a middle, and an end that is coherent. It can't just be any story. You can't just make up any story. It has to fit within certain bounds, the bounds being the rules of law that apply. Knowing the rules of law that apply, you construct a factual narrative, a story that remains within those bounds. Think of it as a highway with guardrails on both sides. You stay on this highway, you're proceeding to a determined destination. You have guardrails, you can't veer off the road. What is required is not just any story, but a story that wins sympathy and is as compelling as possible. What makes a good story? Well, you don't have to have 40 years of litigation experience to know that. You've read books, you've read novels, you've watched cinema and television. A good story is one that holds your interest, that keeps you interested, even entertained, like a well-written novel or an engaging, engrossing cinema. And preferably, this story includes a nasty or dishonorable villain, the other state, and an innocent, righteous victim. You know who I'm talking about. A grave wrong done to the victim, which offends our sense of justice and compels us to seek a way to make things right in the end. Now, what I've just told you probably describes thousands getting a little too aggressive here, thousands of Hollywood movies and many thousands of novels, not always well-written novels, but novels that you pick up and read on the beach or when you want to be entertained. They follow this pattern. And it's important when you think of developing your case and your factual narrative that this is a story that you are telling to an audience, that you want them to read in the written phase and then listen to in the oral phase with interest, maintaining their interest, winning their sympathies, and causing them at the end to conclude, this is terrible, something has to be done about it, and I'm going to do that. If you approach your written and oral pleadings with this in mind, it will be of great assistance to you in developing your factual narrative for a variety of reasons, which I will come to. Now, this is not a novel. Your story, our story, is not a work of fiction. So it has to conform to the facts, to the evidence, which we have to find. And as I said, it has to be consistent with the rules, the rule of law, so that if these facts are convincing to the court under the applicable law, you win. You get what you're asking for. So developing our factual narrative, we have a storyline, a sympathetic, interesting, compelling story that is rooted in the facts. And how are the facts determined? By the evidence. We have to find evidence to support each factual statement that we make in the course of this entire narrative. Evidence that connects one fact to the next, and to the next, and to the next. Our story is a series of facts, a description of a series of events. This happened here. This person said this. The next person reacted this way, etc., etc. Each of these is a factual statement that is only a fact if we have evidence to support it. So how do we start developing this story? How do we know what story to tell? Well, of course, we know the basic rules, the law, but we start when we first meet the client or when we first start considering it, what facts do we have? What does the client think happened? And how does it know that this happened? So what we have is a group of facts. This happened, this happened, this happened, this happened. And we have to organize these facts in a way that forms a narrative. One thing leads to another, another, another. Now, we start with facts for which there is some evidence. What we have is like we're starting to do a jigsaw puzzle. And we have a number of the pieces to begin with so that we have a pretty good idea of what the whole picture is going to look like. And we now have to look for other pieces to fit in to complete the puzzle. That is, to complete the narrative step by step with facts or pieces, new pieces of the jigsaw puzzle that we have to find to fill in and fit together. Now, sometimes when we start, we don't have all the pieces of the puzzle. We don't have all the facts, but we usually have enough to form an idea of what this, that if and when we do complete the puzzle, what kind of picture it is. That is, we know what it is we're striving to show. So we might discover this is a bird. We know this is a bird, and we think it's an eagle. But as we find new pieces, as we search for evidence, new facts, new pieces to the puzzle, and we fit them into the puzzle in the proper place, we find that we were right. This is a bird, but it's not an eagle, it's an ostrich. The facts, in other words, partially confirm what we think the narrative is, but not entirely. That means we have to adjust the narrative to fit the evidence. So when we start out with what we think our narrative is, we have to start somewhere. And we start based on the facts that are given. But as we find more facts, it may confirm that this picture is what we want, what we think it is, and what we want to present to the court, picture of what happened. But we also have to be alert to the fact that, to the possibility that as we find new evidence, it's going to take us in a slightly different direction. And we can't force the narrative on the facts. It's the facts that form the narrative. We have to alter the narrative to fit the facts. Now, there are limits. The narrative still has to take us where we want to go. Otherwise, it's not going to serve our interests. But it may follow a different route, or it may take us to a bird, but not the bird that we initially thought, and we adjust our theories accordingly. In the end, we have to remain faithful to the facts. Now, before we get to the lunch break, I want to talk about evidence. Where does this evidence come from? And this is where I think is really the heart of any presentation on the practice of litigation. How we put the case together, where we find these pieces of the puzzle, what pieces of the puzzle are valid and usable, and where do we find them? Well, the starting point will be contemporaneous documents. That is, documentary evidence that was prepared prior to the commencement of the dispute, or certainly prior to the initiation of litigation, so that the documents were prepared in the normal course by responsible officials before there was an idea that there was going to be a litigation which might affect how they drafted these documents. That's what I mean by contemporaneous documentary evidence. You start with your own files. Now, the relevant documentation may not be limited to one ministry or agency. So you have to identify which parts of the government would have files that are relevant, that have documents which will inform me of all of the facts I need to know to put my story together. Now, you're not limited to documents in your own files. You can look elsewhere, outside the government, for documents that are both authentic, relevant, and credible, because they weren't prepared for purposes of litigation. I'm in a case now before the ICJ for Guyana against Venezuela, where Venezuela is challenging the validity of an arbitral award from 1899 that established the boundary between Guyana and then British Guyana and Venezuela. So by challenging the validity of the arbitral award and the boundary that resulted from it, Venezuela is now claiming 70% of Guyana's territory. So one of the grounds on which they are challenging the validity of the arbitral award is they are challenging the validity of the treaty which Venezuela and the British made agreeing to the arbitration, basically the compromis. Saying the treaty is invalid and therefore the arbitration and the award are invalid. And what they are saying is that the treaty resulted from a conspiracy between the British and the Americans to conduct an arbitration which would result in the British Guyana, winning and Venezuela losing. This is the argument. So, of course, there are files on diplomatic correspondence that Guyana doesn't have, or Venezuela doesn't have, in the British archives and in US State Department archives. There are also the papers of the US Secretary of State and the British colonial secretary who negotiated the treaty. The US was acting on behalf of Venezuela and with Venezuelan participation. So what we have done is we've gone to the Library of Congress in the United States and researched through the papers of the then Secretary of State of the United States, and we've uncovered all of his correspondence, public and private, with his British counterpart concerning the negotiation of the treaty, to use to show that the good faith in which this treaty was negotiated, and not as part of some conspiracy to deprive Venezuela of territory that rightfully belonged to it. So your search for contemporaneous documentation can take you far and wide, outside of your own state's files, into other states, and particularly publicly accessible documents that could be anywhere. Now, another extremely important source of evidence are statements, declarations made by the other state. Among the most compelling and probative forms of evidence are statements against interests or admissions made by the other state, usually made before the litigation has commenced, or even before the dispute has commenced, because they're not thinking about how this is going to impact their position in a lawsuit against them. And let me give you some recent examples of this. I was counsel to Palestine in the advisory proceedings before the ICJ on the legality of the prolonged occupation, settlement, and annexation of Palestinian territory by Israel. And one of the central arguments which we were making was that this may have started out as an occupation of Palestinian territory, but it has evolved into an annexation of the Palestinian territory with the intent to incorporate the West Bank, East Jerusalem, and ultimately Gaza permanently into Israeli territory. So how we proved this to the court was first by looking at Israeli legislation, formally annexing East Jerusalem, formally declaring parts of the West Bank to be sovereign parts of Israel. And we looked at statements made, public statements made by Israeli leaders, prime ministers, ministers of defense. And during my oral we did this in the written pleadings, but in my oral presentation, we showed official Israeli maps showing Israel from the river to the sea, from the Jordan River to the Mediterranean Sea. There was no Palestine, there's no West Bank. It was labeled Judea and Samaria, the names that Israel gives it. And we had a series of slides showing statements by various prime ministers, not only the current prime minister, declaring Israeli sovereignty over the areas where their settlements exist, over extensive areas in the West Bank, and certainly over East Jerusalem. When you can use statements by the other side against it to form part of your story, they become among the most compelling parts of your story. If the other side has said it, they can't, it becomes very difficult for them to say, we challenge this fact. It's not a fact, it didn't happen. We have evidence that they said it. They can't challenge that the source is inauthentic. They're the source. It comes from them. So we always look for statements by the other side that we can use against them. Often that's the most effective evidence that you will have in your story to make it a compelling story and to lead to the conclusion that you want. I can't cover every conceivable source of evidence to support your factual narrative, so I'm going to focus on the main ones. And another very important source are the reports of international organizations, particularly if they come from authoritative, independent, or objective bodies. What the court found most compelling for the issuance of provisional measures in the Gambia-Myanmar case were two extensive reports, hundreds of pages each, by the Independent Fact-Finding Commission appointed by the UN, the Human Rights Council, to investigate the subject of genocide in Myanmar. The court, as a United Nations body, places heavy reliance on reports by sister United Nations agencies, particularly if they are composed of independent experts, authorities in the field, and their methodology gives a high degree of credibility to their findings. It's very difficult for international courts to find facts on their own in complicated situations, particularly where the facts really emanate within another country that is not very receptive to the court investigating. So the court has to rely on others to provide it with facts that it will consider reliable or credible. And one of the main sources that the court historically has found reliable are these investigative or fact-finding reports by authoritative UN agencies. I was in a case between Argentina and Uruguay over environmental issues affecting the Uruguay River, which was the boundary river between the two states. And the question was whether a paper mill on the Uruguayan side was polluting the river in a way that would affect Argentina's interests, since they are co-owners of the river. And what the court relied on, I'll come to this again, what the court relied on were the reports given by the independent experts retained by the World Bank. There was no United Nations report to rely on, but the court found that the independence and expertise of the experts who prepared the report made it credible and worthy of reliance. Now, let me talk about witnesses, and I will come back to witnesses when I talk about the oral hearings, the oral pleadings. Witnesses are very important to your construction of the factual narrative, but with certain limitations. By witnesses, I mean people who participated in the events, who have firsthand knowledge of the events that form the elements of your narrative. They're very important because they can help you fill in certain details. They can explain things that seem to you confusing or contradictory. And they can point you often to places where you can find other kinds of evidence. They may know where the documents are, or where to look, or they may be aware of reports done by authoritative agencies, or they may be aware, because they participated in the events, of statements against interest made by the other side. So it's very important for you to gather everyone who has knowledge about the circumstances and interview them and extract from them as much information you can in order to develop your story, your factual narrative. Now, there's a difference between using the witnesses as sources of information or sources of information about where to find evidence and actually using them to testify before, as testimonially, to give their testimony, either in written form or orally at the hearings. And I'll come back to this in a little bit more detail this afternoon when I talk about the oral pleadings. But international courts, the ICJ, ITLOS, international courts are very skeptical about witness testimony, lay witness testimony, I mean, other than experts. And I think one of the reasons is that international courts are composed of judges from different legal systems, some of which, like those from common law countries, are very accustomed to having witnesses testify with lawyers examining them. And others where the witnesses are interviewed by the judges prior to any kind of oral proceeding. They're not they're not presented by the parties, obviously for partisan purposes, or questioned by counsel for one side and the other, whose interest is partisan rather than, in the opinion of these judges, getting the truth out of the witnesses. So we find that while common law judges might be more comfortable with hearing witness testimony, judges from non-common law countries tend to be very skeptical, regarded as a waste of time. So it is only in very rare circumstances before the ICJ or ITLOS that you would actually call a witness to testify. And even if you have written statements, declarations, affidavits, they're not likely to be considered very seriously by the judges.